Well, Chille's got his latest federal lawsuit, so I thought I would take a quick look at it. I'm not going to rewrite like the other ones. I'm not bothering with that. I got too much to do. But let's take a look at some initial observations. I'm not going in the time element that I used to because it wasn't really worth my time. The writing is getting better, but it doesn't read like a trial lawyer wrote it. It has logical inconsistencies. It has problems, but what we'll do is we'll just stand back and allow it to be attacked. See, it's already been filed. And the things I'm mentioning now are going to be mentioned by the lawyers anyway, and they're going to mention more, which I'm not even going to get into. So minor things, you're supposed to bold and center this, no big deal, 14-point font. Noticed here, he's saying that he's suing Judge Zimmerman in her individual capacity while calling her a judge. Same with Judge Levitt. A little ironic that he's suing the judge that reversed his two convictions. Of course, that reversal was a ridiculous decision. It was absolutely ridiculous. It had no basis in law, in fact. In fact, I proved that the order that was entered was wrong as well. Couldn't even get the name of the case right, Wilson with 2 L's. I think he filed 5 grounds for appeal, lost on 4. And the one that I quote unquote got wrong was the one that wasn't even briefed in the appellate brief. I mean, if this was a real appellate proceeding, that would have just never made the light of day. But whatever. Hey, you know what? I congratulated him. He got the win. Here, I forgot, this isn't being written by anyone else, so I had to strike out the comes now. Normally, you just say Jose DeCastro and then define it as a plaintiff. National commentator, right away, that will cause him to be either a person who is a public figure or a limited purpose public figure. A limited purpose public figure be somebody who inserts themselves into public dialogue. So let's say there is a national crisis regarding, rectal thermometers, and the person then inserts themselves into the national discussion, leading for the change of the way rectal thermometers are made and marketed. We would say then by inserting himself into that dialogue, he has made himself a person that's of a limited public person because it's for a specific purpose. Now, that is not to be confused with a person who is of limited purpose. That's altogether different, and that is not what we're talking about. Couldn't help myself, a retaliatory prosecution. Well, there's facts that are missing here that causes them to be inferential leaps that go wrong. It's a balancing act. I mean, I don't know why it was written and sometimes the way it was, but it says a constitutional rights advocate following his exposure of police misconduct. And that's not really developed very well, but it is an introduction. Jose DeCastro, a national commentator. Now we'll get into malice now, constitutional malice for his defamation claim. Arrested, convicted, and incarcerated. And then I made 4 violations of his constitutional rights. I mean, that's really what this is. The presiding judge, he doesn't identify who it is, but if you know the case, then you know who he's referring to. Formerly married to a law enforcement, proposed a sentence, so no similarly charged defendant ever received before. Well, he's only referencing one NRS statute right here, this, but he was actually convicted for 2, so another mistake, okay? And so also I gave him it was either Hibbert or Heibel, a little foggy in my memory, it was December of last year, and that actually, ironically, was on his trifold. And that case said no jail time for convictions of resisting and obstructing, and the obstruction was a little different. It was a local charge, but still the idea was the guy only got a $250 fine going all the way up to the Supreme Court of Nevada. I gave him that. That was his literally get out of jail card for $200 if he or his lawyer would have just submitted it to the judge, especially when the prosecutor only asked for a suspended sentence. Large swing and a miss. Tried to help you there, Chille. And then here it says, basically they're saying that Judge Zimmerman is biased because of her background. Well, one big problem for you there is judicial immunity. Secondly, you only have a certain amount of time to disqualify a judge. And at least in California, it's a 170.6 motion. You would do it within a certain amount of time and usually before any major decisions or any decisions on the merits have been made by that judge to prevent judge and forum shopping and things like that. So if you're claiming that she retained his surname after the divorce, then that would be disclosed to you. I mean, how'd you find it out now? Could have found that out before the trial or before before she sat on your, sat and listened to your case. The core issue was plaintiff's criticism of law enforcement. I don't agree with that. Not in terms of your conviction. This was a little bit strange. She says, what should have been a citation. Well, that is actually a very careless thing to write right there, because it suggests now that you're saying that you are admitting that the encounter was valid. You only should have issued me a citation. For what? Wrongful conduct? Ooh, ooh, ouch. Oh. What's that? Dr. Evil? I've been hearing from him and Scott. You guys know about that. Scott, did you write that in the complaint? Scott? Where are my laser beams on the heads of my sharks? Okay. In 2023 and 2024, I don't really like the way that's written either. Platform reached over 40 million views. Now we get into defamation. When he tries to bring that case, if he does, he's now under the standard of constitutional malice, which means person who's being sued has to be reckless or malicious in a way that it's a lie. Not negligence anymore. Malice, constitutional malice. Regularly exposing excessive use of force, caution about. Okay, so anyway, then I said, I took this out, resulting judicial and prosecutorial retaliation. I mean, I'm not writing this for him, but I can't help myself because I just, This was arrested, filming a traffic stop. Not true. It wasn't because of the traffic stop that you were filming. Judge Zimmerman said that. A misdemeanor charge followed. Actually, there were 2 misdemeanors. So this is a problem. I talked to Scott during the break, and he's apologizing. He's lost more hair over this. Judge Zimmerman denied scheduling flexibility. Well, guess what, Chille? I just had a trial in Los Angeles where the judge refused to move the trial date. It had nothing to do with judicial bias. He just didn't want to do it. He didn't think there was a reason for it. And also, she did grant you continuances. Remember when she gave you an extended continuance because you said you're going to be out of the country? Remember what they're going to say back to you. Refuse standby counsel, which is always kind of an iffy thing anyway for a judge. They don't really like it because you don't know what you're doing as a lawyer because you're not a lawyer, and then you make an error, and then what the other lawyers will say, oh, hey, you know what, we'll try to fix that now. These are constitutional liberties, in essence, she's trying to protect, which is why she went with an experienced attorney like Michael Me and not you, because you're not a lawyer. So these are all conclusory statements, exculpatory evidence, accepted false officer testimony. Bottom line is that is part of a trial, unfortunately, and she has the decision as the trier of fact to decide whether or not she believes him or not. Okay. And then if you sue him for his false testimony, which is what I thought I saw you say on a video, at least in California, that's protected by the defamation, the litigation privilege. So that would be anti-SLAPP as well. And then I just kind of messed around with this. On March 15th, plaintiff was arrested and charged with 2 misdemeanors. Be better because you only say 1 here. And okay, plaintiff was also subject to unlawful physical search. Well, what law was broken? What statute was violated? If it's unlawful, explain why. By bailiffs under Judge Zimmerman's direction. Well, now, at least in California, if she's making decisions from the bench, she has immunity, okay? There are grounds where a judge does not have immunity, for example, personnel decisions and things. And that was one of the cases, the Forrester case, I think you cited. Well, by the way, the Forrester case was amended in 1996. So you are absolutely right, Chille. You need legal research tools that the professionals use. I use Lexis. I like it a lot better than Westlaw, but it's a matter of personal preference. I don't like Westlaw. I've been using Lexis for 20 years. And I have found all kinds of cases. And without it, you're kind of in a bad situation because you're going to have the other attorneys who probably are trial lawyers like me loading up on the cases. It's going to come down to a battle of pleadings before we even get to the point of the trial. And remember, when you appeal this, because I think you said you expect to lose, the appellate record is developed by what's argued at the trial court level. And that would include pleadings, especially if they lead to dismissal. Bailiffs under Judge Zimmerman's direction, well, again, if that was an order from the bench, like what happened in LA, then you know what? There's immunity. Disrupted plaintiff's assembly with supporters. How does that really be a right that was that you were deprived of? You said reviewing judge is better since you got more than one judge named to name who it was. And she vacated the bond hearing process because your attorney submitted to her the same brief, and believe me, it was brief, 4 pages, cited to one case, if I remember, and it even didn't cite to the case that actually mattered, which was post-conviction relief, not pre-trial detention. There's not much for her to look at. So now you're claiming that's a violation by her? Well, no, you submitted that through your lawyer. So no, that argument sucks. And suffering irreversible professional harm. That's not what you're saying on your YouTube channel, because I do watch your channel, Chille. Plaintiff's conviction, since you were convicted of more than one charge, you would make it plural, ultimately overturned. Ultimately is a weird word. I see trial lawyers using that word. Ultimately, we'll have to decide ultimately what the ultimate facts are, but ultimately that's your decision. No. But not before he spent 4 months in jail, missing his cousin's death, and suffering irreversible professional harm. Irreversible. Well, if you're asking for $45 million, remember, Dr. Evil is here, then it sounds like whatever harm you suffered, it would be fixed by the $45 million. If not, explain to me why I'm wrong about that. If you're talking about irreparable harm, that's harm that cannot be remedied by money. In here, just notice that conduct taken outside the scope of judicial immunity, and you would kind of want to include that again as it's. And then I thought it would be John Holmes. I thought was not Doe. There was a John Doe, by the way, as well, who was the compatriot to John Holmes, for those of you keeping score. Judge Zimmerman immediately denied plaintiff's request without inquiry. That, believe me, that happens all day to us. That doesn't make the judge biased. It just said the judge said no. And remember, she did grant continuances. Look at the docket. You leave out a lot of dates. This demonstrated her early bias conclusory. And again, if you could find out these facts about her before she took the bench in your case, then you really are handicapped when you say that it's the reason why you needed to get a different judge. And then you mentioned that her last name was retained by the cop and that this was never disclosed. Well, I don't know that a judge needs to make a disclosure about who she was married to and why she kept their name. But if you found this all out and the name she has is the name of the prior cop, then it was disclosed because it's already out there in the public domain. I still wouldn't do any of this. So that leads me to question how a federal judge would look at this and say, are you asking Nevada now to disqualify every judge in a criminal case and where they were married, dating, a family relationship with a police officer or former police officer? And then what about the former prosecutors who become judge? Plaintiff was arrested while lawfully filming a traffic stop. Kind of misleading. So you're leaving stuff out that kind of fills in the cracks. Anyway, physically searched by bailiff's judgment's direction. So this sounds like an authorized act. And then you mentioned this was a little unusual. You put this right next to something else. It was executed. Avoid using it. It is a very unconventional way of starting a sentence, an indefinite pronoun. Then it has to refer directly to what it was referring to before. And was performed in a demeaning manner. The search was demeaning. And then right after that, you mentioned how you called the person a pig. So let's kind of like balance that one out for a second. Kind of a problem, isn't it? You do not like that the search was done in a demeaning manner, which just looked kind of routine to me, but you called the other side a pig. Okay. And when it says judge proceeded to trial without recusal, well, did you try to recuse her? Did you try to get her to step down? Did you file any motions? Did you paper the judge, as they say? No. And I just said, and none of these were, none of them were incarcerated, some shit like that. Again, I'm not really trying to rewrite this thing. Then I was just mentioning plaintiff's sentence of 30 days for each conviction represented a major departure for all prior sentencings for similar defendants. You might want to start, and this was just off top of my head, took that out. This looks like it was really part of your Monell claim. There's really no such thing in my book as an ex parte communication between a bailiff and a judge because she works for the judge. All of these pretty much are conclusory, which will not bode well for you on the 12B6 motions. Paragraphs need to be numbered, prior incorporation of allegations for that specific claim. Just writing a couple of sentences for each claim that'll invite an attack right away. And then for Forrester, you called it an administrative act. Well, there's the functional test, Chille. I took a look into it because I don't practice the kind of law, but it took me all of 20 minutes to kind of understand it. The Forrester decision you mentioned here, I don't know where you got it from, but it is good law. However, it has been modified. And now it was modified in 1996 for a basis that isn't relevant here. But you see, you would have to reference to the judge that there was an amendment to that law and partially overruled and changed by federal legislation. Then all conclusions. Here is where Dr. Evil enters the chat. By the way, on a Monell claim, you're trying to say that the county, the city, the government is responsible for all this abuse. The employees that do this, the county's not responsible for that. But you have to show that the county is the decision maker, the one who makes this happen and is indifferent and all that other stuff. So there's no respondeat superior liability. If you find individual cops doing these things, then you still have to go back to the municipality. And you cite cases. I total up was what, $45 million. $45 million. Punitive damages. Equitable relief. Now that will be an interesting argument here, Chille, at least in California. Forgot the civil code section, but the idea of unclean hands, not the YouTuber, but unclean hands, when you do something that is considered wrong, wrongful, and bad, if they can point to that, then you're asking for what's called equitable relief, which is a relief that does not have a jury trial. It's done by a judge, and the judge is balancing the factors. They can use that to deny all claims. The attorney's fees, now that's your major weapon. That's what the insurance carriers are looking at when all these lawyers are on the case, is how can we pay to get out? So settlement, always possible with the 1983 claim. I didn't know about the anticipated defense. I've never seen that before. All right, so that's it. We'll wait for the attack pleadings to come in, and then I'll take a look. Wish you all a good day, and catch you on the next one.